This section covers delays of enforcement in Section 12.4.16 of the Denver Zoning Code. This is a new procedure added to consolidate all the ways the DZC previously addressed delays of enforcement. There were two provisions on delaying enforcement for orders to cease operation of excess dwelling units and all other orders to cease and desist, which both fell under the Board of Adjustment section of the code. That section is meant for describing the board, its structure, its composition, and its powers. And so these two subsections have been moved to a new procedure in Section 12.4.16, which consolidates the two procedures into one. Now, Section 12.4.16 is structured like a typical procedure in Article 12 with an intent statement, applicability, and other subsections describing how a delay of enforcement should work. The intent here is to provide appellants with reasonable time extensions to comply or seek an alternative resolution to violations of the code. This section applies to enforcement of any violation listed in Section 12.11.2, which identifies all the different categories of activities that can be considered a violation, such as increasing the intensity of a use or building a structure out of compliance with the code. A delay of enforcement is initiated when the property owner or operator of a business or other land use subject to enforcement, or their authorized agent, makes a request in writing to the BOA, the Board of Adjustment, within 30 days after one or more of the following has occurred. First, CPD has issued an order requiring compliance with the code, or CPD has issued a notice of violation for operation of excess dwelling units. Or second, CPD has issued any order requiring compliance with the code or a notice of violation for any of the violations in Section 12.11.2. The application and fees are set by the Board of Adjustment's rules. Finally, a public hearing is held by the Board of Adjustment where the board shall approve with conditions, or deny the request for a delay of enforcement based on the review criteria in the following section. The board may also attach conditions of approval that are necessary to protect the health, safety, and welfare of the community and minimize adverse impacts on adjacent properties. These can include, but are not limited to, conditions modifying operating characteristics of a non-conforming use. The review criteria for a delay of enforcement ask that the board find that literal enforcement of the provisions of the code will result in unnecessary hardship by reason of unique and exceptional circumstances. The board can order a delay of enforcement for no more than 5 years for operation of an excess number of dwelling units, or 6 months for all other violations of the code. One important thing to note here is that the board can take into consideration factors related to the person or people involved, which is not allowed when they are considering other types of cases like variances. When a delay of enforcement is granted, it pauses all enforcement activities, including accumulation of fees and penalties. Second, like other actions of the Board of Adjustment, the delay of enforcement shall be recorded against the property with the clerk and recorder. Third, a delay of enforcement shall not be a variance on the use of a premises and is personal to the applicant and not transferable. This is an exception to the broader effort in the bundle to remove regulations that are personal to the applicant. This is because the board can consider unique and exceptional circumstances that have to do with the owner's circumstances or who they are, such as their age. Since the board's decision can be based on personal characteristics or circumstances, the delay of enforcement is no longer valid if the property is transferred to another owner. And lastly, a delay of enforcement for operation of excess dwelling units is only valid to allow continued operation of those dwelling units for use by the persons occupying such unit at the time of the original order. So this means that a property owner cannot obtain a delay of enforcement for 3 years, then turn around and rent the unit to a new tenant if the original tenant from the time of the order moves out or for some reason no longer occupies that particular unit. Under this section, expiration and extensions, the Board of Adjustment's order for a delay of enforcement can be extended if the board finds that the original conditions found according to the review criteria still exist. Think, for example, of the unique and exceptional circumstances that we discussed in the previous slides, for example, having to do with a property owner's age or some other factor. Extensions may be granted for a cumulative total of 5 years for operation of an excess number of dwelling units, or one extension for a maximum of 6 months for all other violations of the code.